All right, we're calling this meeting to order. Will the clerk call the roll?
The role for the Joint Commission to oversee the transition of the Commonwealth into a cannabis retail market. Delegate Krizik.
Aye.
Delegate Price.
Here.
Delegate Carlson.
Here.
Delegate Cousins. Here. Delegate Moorfield. Here. Delegate Fowler. Senator Eben.
Here.
Senator Craig.
Here.
Senator Aird.
Present.
Senator Salim.
Here.
A quorum is present, and at this time, the first order of business is going to be for the election of a chair. Nominations are now in order.
Yes, I would like to nominate Paul Krizak to chair the commission.
Second.
It's been moved and seconded that Delegate Krizik be nominated as chair of this joint commission. Are there any further nominations? Okay, the nominations are closed. All those in favor of Delegate Krizik being chair of the joint commission say aye.
Aye.
All those opposed? All right, Delegate Krizik is the chair, and he'll now take over and run the election of the vice chair.
Thank you, Kathy. Welcome, everybody. I have a nomination for vice chair?
Mr. Chair, I would like to nominate Senator LaSharice Aird.
Do I have a second?
Second.
Okay, it's been moved and seconded for Senator LaSharice Aird. Remember, she started with me in the House, so she's always a delegate in my, same class. We're the only two left standing, I think. No, I'm sorry. Hello. 3 of us are left standing. But the 2 of us, Sia and I are the only 2 in the House, though. But it's nice to have you and as a vice chair. But before we have it, we got to elect you. Make sure there's no other nominations. Is there anybody else interested in being vice chair? Seeing none, do I have a, all those in favor of LaSharice Aird, Senator Aird, as our vice chair, please signify by saying aye.
Aye.
Opposed? Okay, the ayes have it. Congratulations, Madam Vice Chair. It's good to be with you all. Members, before we start, I'd like each of you to have an opportunity to introduce yourself and explain your interest in serving on the commission, if you will. If you're not interested, let us know now. But we'll start at the, let's start with the Senate. We'll start at the end of the row here.
Hi, everyone. I'm State Senator Saddam Salim. I represent Central Fairfax. I'm looking forward to the things we could be doing in this committee. Thank you.
Hi, I'm Senator Christina Craig. I represent Senate District 19, which is parts of Chesapeake and Virginia Beach. I'm here because my constituents hired me to make the hard decisions, and I'm here to learn everything about both sides, and I want to make sure we do it correctly. Thank you.
Hi, good afternoon, everyone. I'm LaSharice Aird, and I represent Senate District 13, which include 8 diverse rural, urban, and suburban communities here in our Commonwealth. As Paul said, we started out on the General Laws Committee in the House of Delegates, first working on the very first variation of this legislation, and I love to see it come to fruition in the form that best meets the needs of our Commonwealth.
Good afternoon. I'm Adam Eben, Senator from Alexandria, also representing parts of Arlington and Fairfax. I had the pleasure of passing legislation initially to remove the penalty of losing your driver's license for possession of cannabis, and then eventually decriminalization and finally legalization of cannabis a number of years ago. But we did not complete the task in terms of setting up the retail market, to my regret. And I'm here because I'm very interested in seeing us finish the task and in doing it as well as possible.
Thank you. And I'm Paul Krizak. I represent Mount Vernon and Franconia magisterial districts of Fairfax County. And like my colleagues, I'm interested in doing it right, and finally getting the opportunity now. Really, what I really love about being on this commission, I think, is that we're going to have a lot of opportunity to get to generate some public input and from the stakeholders and from the general public, and do it without being pressured for time, and get a really good bill through for next year, and with my excellent colleagues here. So thank you very much for having me.
Hello, I'm Sia Price. I represent the 85th now, the 85th district and parts of Newport News. And I'm here because I just want to make sure that we keep justice at the forefront of our conversations.
I'm Delegate Katrina Carlson. I represent Charlottesville and parts of Albemarle, and there is such a thing as being voluntold to do something. That being said, I feel it's an honor and privilege to work on such a massive piece of legislation that's going to have an impact across our Commonwealth. The lens that I bring is as a former deputy city attorney, so interest in zoning, procurement, making sure that as this market is established, it's equitable, it's safe, and it serves us all.
Hello, everyone. My name is Delegate Ray Cousins. I represent the 79th District, which covers some parts of Richmond. As we move towards a retail cannabis market, similar to Delegate Price, I am definitely interested in making sure that especially in a district like Richmond, where criminalization previously greatly impacted our communities, just making sure that the retail cannabis market is equitable and that we are also taking into account and protecting small businesses and farmers as well.
Good afternoon. I'm Will Moorfield, representing the 43rd District in Southwest Virginia, the coal fields of Southwest Virginia, and I look forward to serving with all of you on the commission.
Hello, I'm Delegate Buddy Fowler. I represent the 59th House District, which is predominantly Hanover County and Louisa, and I have a little slice of Henrica County. I think, like everybody up here, I have some reservations about where we're going here, but I'm hopeful that we can put together a bill that will work for everybody in this Commonwealth. And so looking forward to the process. Thank you so much, Mr. Chairman.
Thank you, committee. I appreciate all the time you're going to spend on this. As you will see with the agenda today, which I'll go over right now, there's a lot happening, and we expect to have 3 more meetings this year, including one that's already scheduled next month on August 20th. And we'll continue to meet through July 1st, 2028, when this commission expires. Also want to thank our attorneys, Stephen and Troy and Taylor, and our clerk, Kathy, for their hard work. And I know they're going to be doing a lot of heavy lifting throughout. Today's agenda, we're going to start with, the next item on the agenda will be a quick review and adoption of the virtual meeting policy. So that will allow members to be online, but also allow for the public to testify or to ask questions and have public comment online as well. And then we're going to have a review of the bill that created, of the resolution HJR 497, which created this commission. And after that, we're going to have a presentation entitled Cannabis in the Commonwealth, an overview of the background and current status of marijuana legalization in Virginia. And after that, we're going to have a presentation from the Virginia Cannabis Control Authority on an overview of the Control Authority and medical cannabis program. And then we're going to allow for 30 minutes for public comment. And we don't have any sign-up sheet, but that doesn't mean you won't get an opportunity. So when we get to that point, I'll explain what you need to do to comment, but everybody will get an opportunity to speak. And then we will adjourn to the next meeting on August 20th. I just want to remind also all the stakeholders and the public that there's going to be a lot of opportunity for engagement. So if you don't get to speak today, it doesn't mean you won't have another opportunity because we want to hear from you. This is important, and this is going to be historic, really, and it's an opportunity we really want to hear from our constituents, and also any stakeholders who are interested in being presenting before us in a future meeting. Don't hesitate to reach out to the clerk, to me, or any of my colleagues, and we'll make sure you're on there. I just want to remind everybody, why we're working on this retail market bill. It's because historically marijuana laws have been ineffective, and they've had devastating collateral consequences for individuals and communities across the Commonwealth, especially African-American communities. Our goal is to create a successful approach to cannabis that's rooted in protecting the public, the principles of restorative justice, economic equity, and public health. The need is to regulate, control, and tax marijuana, to generate significant revenue dedicated to community reinvestment, create hundreds of new small and local businesses, strengthen Virginia's vital agricultural sector, and end the racially disparate impacts of prohibition. And of course, most importantly, probably, I think, is protecting the health and safety of all Virginians. And making sure that we have money also for the pre-K public education. So the goal of this commission during this first year, as I see it, is to really engage heavily with the public, and I've mentioned that a couple of times already, so you know it's a priority of mine. And the idea will be to craft the best bill possible to reintroduce for next session. We've already been pretty successful. Senator Eben mentioned his efforts originally. We've made some big progress, and this will be the final capstone on that progress. So without further ado, I call up, actually we've got to do the virtual meeting policy. Stephen is going to lead us through that.
Thank you, Mr. Chair. So the virtual meeting policy tracks pretty much the ones all of you have seen before. There are two main components: remote participation by individual members during an in-person meeting. The highlights of the policy include we still need a quorum physically assembled for an individual to participate remotely. If all requirements are met, that member may participate in all business at the meeting, but they will not be allowed to vote and they will not be counted towards a quorum. The second piece of the virtual meeting policy is when we do hold all virtual meetings, we are limited by law to 2 electronic meetings per year or half of those meetings held. We may not hold consecutive all virtual meetings. Any all virtual meeting shall only be conducted for purposes of receiving presentations, updates, public comments, or to conduct other forms of information gathering, no votes or recommendations. And it's in the left side of your folder, Mr. Chair.
Thank you. Is there all the committee members? Senator Eben.
Yeah, I wanted to ask counsel, did you say that if you participate virtually in this policy the way it's written that you can't vote?
Mr. Chair, Senator Eben, that's correct.
Oh, okay. I guess
under this policy.
Okay, and I guess that's in keeping with the House's policy. So if it's in order, I would make a motion that we adopt the virtual meeting policy.
Second.
The policy's been moved and seconded. All those in favor signify by saying aye.
Aye.
Opposed? Okay. The ayes have it. The policy is adopted. Thank you. Now we're going to go to a review of HJR 497. Troy is going to walk us through that.
Thank you, Mr. Chair, members of the commission. Just a quick overview of HJR 497, which was Delegate Krizik's resolution, which passed this year. This resolution addresses that in 2021 Special Session 1 from House Bill 2312 from Delegate Herring and Senate Bill 1406 from Senators Eben and Lucas passed, which legalized possession of marijuana and cultivation of marijuana under certain conditions, and it also created the Cannabis Authority and certain other provisions of licensing and regulatory framework, which were subject to a reenactment, which failed to pass the next year. And then in 2024, the regulatory and oversight of medical cannabis transitioned from the Board of Pharmacy to the Cannabis Control Authority itself. So this resolution created a 10 legislative member commission, all of which are here today. And the commission has 4 main goals. The first shall be to oversee the administration of responsibilities assigned to the authority under the Cannabis Control Act. The second is to oversee the implementation and enforcement of cannabis-related laws and regulations. The third is to monitor issues, trends, and impacts related to cannabis. And the fourth is to examine, in consultation with the Cannabis Control Authority, any necessary legislative changes to the medical cannabis program that would make the program more competitive, accessible, and economically inclusive. This commission shall meet at the call of the chair or whenever the majority of members request. No recommendation shall be adopted if a majority vote against that recommendation or they vote for a recommendation to fail, notwithstanding the majority vote of the commission. And an annual executive summary shall be submitted no later than the first day of each regular session to the General Assembly. And as Chair Krizik already mentioned, the commission is to sunset or expire on July 1st, 2028.
Thank you. Are there any questions? Any comments? All right. Without seeing any, we'll go on to item number 5, and that is Troy. You're going to start us off, I think. Am I correct on the presentation? Do we have? We also have. We have PowerPoint, right? Okay. let me, if it's okay with you, Troy, encourage my colleagues to interrupt at any time, ask any questions. And that's why I ask if it's okay. Is that okay? Yeah. But I feel like sometimes it might be pertinent at that time, and otherwise you might forget, or it might get buried. So if it becomes problematic, then we'll reassess that idea. If Troy's losing his train of thought, then forget that. But anyway, for now, just don't hesitate. Just reach out and say, Mr. Chairman, I have a question for. All right. Sorry, without further ado, go ahead.
All right. Is this on?
Thank you for this.
Is this on? Can everybody hear me? Okay, perfect. Okay, so good afternoon, Commission. Again, my name is Troy Hatcher. I am the House Courts of Justice criminal attorney. So I'll be starting off this presentation along with Taylor May, who is our senior attorney, staffing the general laws, specifically focusing on ABC, cannabis, some of the vices, and then also Stephen Kinderman, who is one of our lead senior attorneys who staffs the Senate Finance and Appropriations Committee. So what we're going to do is we're going to start off with about a 10-year legislative history. So it's going to be brief. So I might not know all the answers, but if you have a question, we can stop and kind of look it up. So a brief 10-year history that will lead into the 2025 different pieces of legislation that were introduced, passed, and vetoed. Taylor May will then take over explaining what that bill was and what kind of some of the current status of the marijuana laws are, which will then also transition from that to Stephen's part, which will address all of the taxation, finance, revenue, all the numbers that I don't do because I am the criminal attorney. So again, with the legislative overview, we're going to start with an overview of medical cannabis. So all the way back in 2015 was the first iteration and the passage with House Bill 1445 from Delegate Albo and Senate Bill 1235 from Senator Marsden. This would have began and did legalize and authorize licensed medical practitioners to provide certification for the use of marijuana in the form of CBD oil or THCA. Notice that as italicized, we will be seeing different changes to the bills if you notice that in your presentation. This was for treatment or to alleviate symptoms of specifically epilepsy. The bill also provided an affirmative defense in a prosecution for possession if the marijuana was in the form of CBD oil or THCA oil and that person had a valid written certification from a medical provider. Then in 2016 and 2017, Senator Marsden did Senate Bill 701 and then 2017 Senate Bill 1027 because there was a reenactment clause on the 2016 bill, which would have authorized a pharmaceutical processor after obtaining a permit from the Board of Pharmacy and under the supervision of licensed pharmacists to manufacture and produce CBD oil and THCA oil to be used for treatment of epilepsy again only. 2018, the Board of Pharmacy awarded the first 5 pharmaceutical processor licenses in September of 2018. House Bill 1251 by Delegate Klein and Senate Bill 726 by Senator Dunavant passed, which changed and allowed medical practitioners to issue a written certificate for the use of CBD oil or THCA oil for the treatment of any diagnosed condition or disease. That is a change from epilepsy to now any disease. This would be determined by the practitioner if that person would have benefited from such use. They were still required to register with the Board of Pharmacy. In 2020, Senate Bill 976 from Senator Marsden allowed those 5 authorized pharmaceutical processors to then establish 5 additional off-site cannabis dispensing facilities within each of their designated health service area. It also had a shift from just producing CBD oil and THC oil to the word was now cannabis oil. Senate Bill 1015 by Senator Marsden also switched possession of CBD oil or THC oil pursuant to a valid written certificate from an affirmative defense to a blanket immunity from prosecution. So what that means is if you were caught with possession and you had to go to court, you had to prove that you were allowed to possess it, whereas now it wouldn't even allow the court case to go forward if you were trying to be arrested and could prove that you had a valid prescription. In 2021, Senate Bill 2218 by Delegate Hayes and Senate Bill 1333 by Senator Lucas permitted pharmaceutical processors to produce and distribute cannabis products other than just cannabis oil, such as botanical cannabis. Senate Bill 2312 from Delegate Herring and Senate Bill 1406 from Senators Eben and Lucas were the legalization of marijuana large bill, which contained an enactment clause that directed that all regulations governing pharmaceutical processing to be transferred from the Board of Pharmacy to the Cannabis Control Authority by July 1, 2023. However, the bills themselves did not contain the necessary code changes, therefore the switch did not happen. In 2022, House Bill 933 from Delegate Robinson and Senate Bill 671 from Senator Donovan removed the Board of Pharmacy patient registration requirement for medical cannabis, but it did maintain the requirement that patients obtain written certification from a healthcare provider to be able to purchase and possess medical marijuana. In 2023, House Bill 1598 from Delegate Robinson and Senate Bill 788 from Senator Favola then moved the oversight and administration of medical cannabis from the Board of Pharmacy to the Cannabis Control Authority with a delayed effective date of January the 1st, 2024. The 2023 bill contained the correct code changes necessary in order to transfer from the Board of Pharmacy to the Cannabis Control Authority. Anything more on medical marijuana will be answered by the Cannabis Control Authority person that is here as well. We're going to jump quickly over to hemp. That is not a huge purview for this committee, but it is relevant to the conversation surrounding cannabis. In 2018, the federal farm bill passed, which allowed possession and growth of industrial hemp. So in 2019, the General Assembly with House Bill 1839 by Delegate Marshall passed, which conformed Virginia law to the provisions of the 2018 federal farm bill, amending our definition of cannabinoidal, CBD oil, marijuana, and tetrahydrocannabinol, THC, to exclude industrial hemp in the possession of a registered person, hemp products, or an oil containing no more than 0.3% of THC. Industrial hemp was defined as any part of the plant Cannabis sativa that has a concentration of THC that is no greater than allowed by federal law. Again, this is the 2019 bill that passed. And it defines hemp product as any finished product that is otherwise lawful and contains industrial hemp. Under federal law, hemp is defined to include any cannabis plant or derivative thereof that contains not more than 0.3% concentration of delta-9 THC on a dry weight basis. In 2021, another bill was introduced for hemp products on HB 2078, which was passed by Delegate Marshall. Various updates were made to the industrial hemp laws, including changes to exclude industrial hemp from certain criminal provisions, which was a necessary change given the legalization. And then in 2023, Delegate Kilgore with House Bill 2294 and Senator Hanger with Senate Bill 903 actually limited the amount of total THC, not just delta-9, that can be included in the hemp product or industrial hemp extract to 0.3% and either 2 milligrams of total THC per package or an amount of CBD that is at least 25 times greater than the total THC package, among other things. The total THC amount would have included delta-8, delta-9, and any other forms of variants. This bill is more restrictive than the federal bill. We are allowed to do that as a state. We can be more restrictive than federal government. We can't be less. And this is what we've kind of been calling the 25-to-1 ratio. That was what passed. So it's the 25 CBD to 1 milligram of THC. Switching over to the adult use of cannabis, kind of going back a little bit, again in 2020, Delegate Herring with House Bill 972 and Senator Eben with SB 2 decriminalized the simple possession of marijuana, transitioning the penalty from a Class 1 misdemeanor to a $25 civil penalty. And also in 2020, a JLARC study was conducted. I've included the link on this PowerPoint. It's a long study, but I have the summary with me. Some of the items that they found, again, this is a 5-year-old study, but from the summary, they found some suggestions such as creating a commercial marijuana market would entail issuing licenses for 5 different types of operations. They suggested that the state could allow localities to opt out of a commercial market, and the current medical marijuana businesses could be allowed to participate in the market. That Virginia could choose legalization to address prior disproportionality in marijuana enforcement, which again happened in 2021. Virginia would need to take measures to mitigate unintended negative public health consequences. Virginia would need to grant regulatory authority to either the VABC or create a new agency to regulate the commercial marijuana market, which is the Cannabis Control Authority that was created, which is now just for medical marijuana, but if this marketplace was transitioned to that, that could be an option. And taxing commercial marijuana sales would eventually produce substantial revenue. including thousands of new jobs creating, and that the marketplace itself could take 2 or more years, but revenue would far exceed the cost after the sales would start. Again, Stephen will touch more on the revenue and sales tax further, but that was basically what Jay Lark came out with in 2020, saying if we're going to do this, here's some things to consider moving forward with this legislation. So from that 2020 study, then in 2021, House Bill 2312 by Delegate Herring and Senate Bill 1406 by Senators Evans and Lucas, once again, legalized the possession of 1 ounce of marijuana, up to 1 ounce of marijuana, and created the Cannabis Control Authority. They were identical, which contained some partial reenactment clauses, some of which became law, but a majority were subject to reenactment. And as we said, some things like transitioning from the Board of Pharmacy to the CCA were not passed because of the reenactment clause. I will say that the commercial adult sales are still illegal, but effective possession of up to 1 ounce is legal. In 2024, recent legislation that occurred were House Bill 698 from Delegate Krizik and Senate Bill 448 from Senator Rouse, which would have established the original bill to establish a framework for the creation of a retail market in the Commonwealth, which would have been administered by the Cannabis Control Authority. This bill was passed. These bills were passed, but then vetoed by the governor in 2024. In 2025, again, we've already talked about the House Joint Resolution that created this commission, which passed. The retail marketplace bill was introduced again with House Bill 2485 with Delegate Krizik and Senate Bill 970 with Senator Rouse. There are a couple tweaks with it, but again, it passed, once again, vetoed by the governor. And then also House Bill 1989 by Delegate Askew would have made some changes to the medical cannabis program, but that also was vetoed by the governor. Going into current law, again, medical cannabis can be more appropriately addressed by the Cannabis Control Authority, but some quick overview for it. This is located in Title 4.1, Chapter 16, the provisions of the program. What it does is allows Virginia residents to use and purchase medical cannabis to alleviate and treat symptoms of any diagnosed disease or condition, as long as they have that written certificate from their medical practitioner. There are limits on how much they can purchase at those facilities, so no more than a 90-day supply can be dispensed, no more than 4 ounces of botanical cannabis for each 30-day period, and medical cannabis products can contain no more than 10 milligrams of THC per dose. These pharmaceutical processors that we talked about earlier are the ones that cultivate, process, dispense, sell, and deliver the medical cannabis products all under one license. There are not different types of licenses for these people, or these processors. The 5 processors in Virginia, 1 in each of the 5 HSAs established by the Board of Health. So there are only 5. Each pharmaceutical processor can have 5 additional cannabis dispensing facilities for dispensing of cannabis products that have been cultivated and produced on the premises of that permitted pharmaceutical processor, and one authorized additional cultivation location. Before dispensing any cannabis products, those processors are required to make a sample from each batch for testing to an independent laboratory. That's a statutory code. And advertising restrictions are located in the code. Generally, there are advertising is allowed in the Commonwealth subject to restrictions, and long as the advertising accurately and legibly identifies that the pharmaceutical processor or cannabis dispensing facility is responsible for its content, includes statements that cannabis products are used for certified patients, and they comply with certain board regulations. As far as hemp laws, the VDAX is who currently regulates hemp in the Commonwealth. They issue the registrations for growing, handling, and processing industrial hemp, and any person selling retail hemp product intended for smoking or an edible hemp product or certain substances intended for human consumption that are advertised or labeled as containing an industrial hemp-derived cannabinoid has to obtain a regulated hemp product retail facility registration through VDAX. So you can't just go sell this on the street. You have to be certified from VDAX. If any location is selling that right now, that means they have that license from VDAX. However, again, like we said, the 2019 bill was the same as the federal 2018 bill, but the 2023 bill made it more restrictive in the Commonwealth. So you can offer for retail sale. The hemp products may not exceed 0.3% total THC and may not have more than 2 milligrams of total THC per package unless the CBD to THC ratio is 25:1. Total THC, again, means all of the THC in the product, including the Delta 8, 9, and other isomers. There are labeling and packaging requirements that go on these products, and in the criminal code, the sale of hemp products intended for smoking under 21 is prohibited. And then this year, we passed the bill that also allowed for penalization and confiscation of products if the person under 25 years of age is possessing it. 21.
Troy, do we have any other questions for him? Anybody want to interrupt? Senator Eben.
Yeah, not so much a question, but a comment maybe for a topic for a future meeting. There's been some discussion about the THC ratio and the total active ingredient of THC included in the product. I think for a future meeting, it would be really helpful to have a discussion about potency and what those all mean in terms of whether there's any impairment or psychoactive properties in the amounts that are allowed in hemp versus medical cannabis, and what the dosage currently allowed in medical cannabis, how that compares perhaps with other states.
Okay. Well, duly noted. The quick question, you mentioned the license for the hemp. Is that, how much is that? Is there a cost to that license?
We will look that up. I think there is a cost licensed. Taylor might know that.
I believe it's $1,000. I believe it's $1,000.
I think it's $1,000.
I know the answer, but I just, good lawyers always know the answer before they ask the question. But I just want to see, just for the general public. So it's a $1,000 license that VDAX charges. Correct, Taylor? Your mic's not working.
You can get up here. You're up next.
Is it? It's on?
It is.
Yeah, $1,000 for the retail, okay, license. Annual fee, correct? Okay, thank you.
Mr. Chair.
Senator Eben.
I also had a question about the 5 health service areas for the medical cannabis. I know there had been one of the areas that had lagged behind the others in terms of having a license issued. There had been some litigation, and then I think it might have been issued. Is there actively in each service area now the ability for medical cannabis in all 5 of our service areas? Is that up and running as far as we know?
Thank you, Mr. Chair. Senator Eben. I think there's been a conditional license awarded in Health Service Area 1, but I don't think they're up and running yet. So there's 4, but it's been conditionally approved, is my understanding. Hoping someone will correct me.
Any other further questions? Delegate Price.
Yes, thank you. And if this is not the appropriate time, it can be answered later. But when we're looking at the packaging, labeling, testing requirements for the hemp products, is there someone that can give us a rundown of the actual picture of what enforcement looks like for this? Who does the enforcement? How big is their department? What does the actual process of enforcement look like? Because a lot of the feedback I've gotten from constituents is that there are products that are being sold that are outside of these legal guidelines, and they don't know who to call or what that looks like.
Yes, Mr. Chair and Delegate Price, I can answer broadly some of those questions, but it may be better if we perhaps had someone maybe from VDAX or something we can find out more information. But VDAX is the entity that regulates hemp, so I believe they do have an Office of Hemp Product Enforcement. I think they probably conduct inspections of the retail facilities. I think they're inspecting them, so they would be the ones to make sure that they're abiding by all the regulations and packaging and testing. There are civil penalties that can be imposed. It's up to $10,000 per day for each violation per day. And I think this is more for the hemp growers and processors, but obviously if it crosses over into some sort of criminal behavior, like if they are knowingly selling marijuana, then that could be obviously handled by law enforcement, or they'd be violating criminal laws. So,
Mr. Chair.
Delegate Price.
If we could maybe have them, VDAX come in, I think we have significant questions for them at some point.
Duly noted. All right, any other questions, comments? We're handing it off to Taylor May, our senior attorney for general law.
Yes, thank you, Mr. Chair. I will be shifting into what the state of the current law is for adult use of cannabis. So currently, since the legalization of cannabis possession in 2021, as Troy mentioned, it is now legal for adults 21 years of age or older to possess marijuana in their private residence for personal use and up to 1 ounce of marijuana on their person or in public. Adults 21 years or older can also grow up to 4 marijuana plants at home for personal use. Note that this is 4 plants per household, which includes everyone living in the place of residence, not 4 plants per person. And if they do choose to grow the plants at home, they have to ensure that it's not visible from a public way. They have to take precautions to prevent access by someone younger than 21, and the plants have to be tagged with the person's name, driver's license, ID number, and a notation that it's being grown for personal use. Also, just to note that property owners and landlords can still prohibit marijuana consumption or growing marijuana in their rental housing agreements. Also, adults 21 and older can share up to 1 ounce of marijuana with each other as long as they're not exchanging anything of value. Now, some things that are still prohibited, it is still prohibited to sell or purchase marijuana outside of the medical cannabis program. It is prohibited to grow more than the 4 plants at home or to manufacture cannabis concentrate from homegrown cannabis. You also can't use marijuana in a public place or offer it to someone else in public. You can't possess or consume it on public school grounds during school hours or school activities. Still illegal to drive under the influence of marijuana. It's prohibited to use or consume it while driving or being the passenger in a motor vehicle. You can't carry it while providing a transportation service like driving a cab or driving for Uber or Lyft. And it still is prohibited for someone under 21 to purchase, possess, or consume marijuana. There are also some advertising restrictions already laid out in code now. The current law under 4.1/1401 says there's no advertising for marijuana other than what can be legally sold, and there's various certain conditions already laid out, but marijuana can't be legally sold right now, so they're not really in effect. And there's also a section covering outdoor advertising and putting some restrictions on where that can be, but right now that's not really because marijuana cannot be sold.
Taylor?
Yes.
That includes medical marijuana too, correct?
For advertising?
Yeah.
There is a separate section covering advertising for pharmaceutical processors. Generally, they can advertise, but there's various conditions and restrictions on that. There's a code section. I think it's in one of the prior slides. And I think there's further conditions and regulations put out by the CCA that kind of restrict what can be in it. But generally, I think they can.
Pretty restrictive. Okay, thank you.
Mm-hmm. Now shifting into some of the bills that were introduced this past session in 2025. This doesn't represent all of the cannabis-related bills that were introduced, but we're just going to focus on 2 of them, the ones that kind of are related to the medical cannabis program and the big retail cannabis market bills. The first one is HB 1989 from Delegate Askew. This was related to medical cannabis. It passed the General Assembly but was vetoed by the governor, and his bill would have changed some of the requirements for what was to be included on the labels for medical cannabis products, depending on the type of product. So current law requires that medical cannabis products contain the total percentage and milligrams of THC and CBD included in the product and the number of milligrams of THC and CBD in each serving. His bill would have changed that so that the total milligrams of THC and CBD and the amount in milligrams in each serving still required for edible and topical cannabis products, but it would just be the total percentage of THC and CBD for inhalable cannabis products. It also would have allowed pharmaceutical processors or cannabis dispensing facilities to deliver products still only in person, but to a residence, including a temporary residence or a business, It's my understanding, I think by regulation, that right now it can just be delivered to a residence. So this would have kind of expanded that. But the bill also would have specified certain places where medical cannabis cannot be delivered, including military base, child day center, school, correctional facility, the state capitol, any public gathering places, including sporting events, festivals, et cetera. The bill would have also defined a delivery agent. Under current law, medical cannabis can be delivered by a pharmaceutical processor or a delivery agent, but there's no definition in current law of what delivery agent is. So the bill would have added that and then also clarified that pharmaceutical processing employees or delivery agents are subject to all the laws and regulations surrounding delivery, and that the CCA could revoke or suspend delivery privileges if they violated any of those. Okay, now shifting into the big retail cannabis market bills from last session, HB 2485 and Senate Bill 970. They were identical. Both bills passed the General Assembly but were vetoed by the governor. Before getting into the details of the bill, just have kind of a table of contents provided here to help kind of navigate the bill. Provides like a general framework of certain sections and page numbers where some of the major components of the bill are located, so may be helpful if you're just trying to navigate the bill and find where something is. So first talking about some of the CCA's powers, duties, and regulations. As mentioned, the Virginia Cannabis Control Authority was established in 2021 when the original legalization bills passed. The board of directors of the CCA is vested with the control of the possession, sale, transportation, distribution, and delivery of marijuana in the Commonwealth. And there's already sections currently in effect in the code related to the powers and duties of the board and regulations to be promulgated by the board. I've noted the code sections there. I'm not going to go through all of it, but I've just noted a few changes here made in the bills to some of those powers and duties and some of the regulations to be made. There's changes related to the social equity licenses, which in the bill have been changed to micro business licenses. Stephen will be going into further detail about those changes in his part of the presentation. There's also a change for the maximum THC level in edible marijuana products, change from and equivalent marijuana products from 5 milligrams to 10 milligrams per serving and from 50 to 100 per package. There's also language added requiring the board to issue a quarterly report that contains various information about licenses, public education initiatives, sales and tax revenue, et cetera. And there's also language noting that the regulations need to ensure that marijuana establishment licenses are issued evenly among all the areas of the Commonwealth. Moving into the criminal provisions, this is kind of lays out just a general structure of how the criminal provisions are in the bill. This is also in the table of contents, but just generally, there's a chapter 11 that's already in code that contains kind of the more general criminal offenses. So this is where you'll find how much someone can possess in public on their person, or illegal sale by someone not licensed, or illegal cultivation, underage possession of cannabis. You'll find that in those kind of general criminal offense sections. There's chapter 12, which covers prohibited practices by licensees, so lays out crimes there. And then there's a chapter 13 that covers some of the criminal procedure sections that will be applicable. And a note that there are a lot of criminal sections in the bill, and many of them are in there just to fix cross-references since the current law for selling marijuana will be repealed if this were to go into effect, and also because it moves the marijuana criminal provisions over to Title 4.1. So a lot of them are fixing cross-references. So there's a lot of sections in there doing that. And then just highlighting a few of the changes to the criminal offenses made in the bill. The bill does increase the amount a person is able to possess on his person or in public from the 1 ounce to 2.5 ounces. And then as mentioned, it does move the crimes for illegal cultivation, processing, and sale of marijuana to 4.1 and would repeal the current crime for illegal distribution or sale of marijuana, which is currently in 18.2 to 48.1. As mentioned, it also lays out criminal offenses that will be specific to or prohibited practices specific to people who've been given a license. And just to note that many of the criminal provisions, not all of them, many of them line up with comparable sections related to alcohol in the ABC sections. Moving into some of the provisions related to testing, labeling, packaging, and other health and safety requirements, just laid out that there are provisions related to testing. The board is to establish a testing program for products, and prior to selling or distributing marijuana to a consumer or another licensee, licensees will be required to submit a sample for testing for contaminants to a licensed testing facility. And there are mandatory testing requirements laid out. This lays out some specifics on what's to be included in the testing, some record keeping of testing, the processes for when additional testing may be needed. That's laid out in that section noted. And there is certain information required to be on the labeling that is laid out in a section, including identifying the type of marijuana, the license numbers of the licensees who have been involved in cultivating, processing, or selling it, net weight, information on any ingredients included, servings, etc., instructions on how to use it. Certain warning statements are required to be included, a universal symbol stamped or embossed, and a certificate of analysis as well. And there are also packaging requirements laid out, required to be prepackaged in a child-resistant, tamper-evident, and resealable package that is opaque. And it can't be packaged in a manner that appeals to someone under 21 in a way that may obscure identifying information, be misleading, or depict or be in the shape of a human, animal, vehicle, or fruit. These are just some of the requirements, but there's more listed in the sections. There's other health and safety requirements for edible marijuana and other marijuana products laid out in 4.11406, one of which is where it includes that these products can't contain more than 10 milligrams of THC per serving or more than 100 milligrams per package. Moving into a large part of the bill, which establishes 5 different types of licenses. The first type would be a cultivation facility license. This would be for growing, harvesting, planting marijuana, and there will be 5 tiers of cultivation facility licenses based on the size. So tier 1, they could grow indoor or outdoor, and would be a maximum of 2,000 square foot canopy. Canopy is the space used by the licensee generally to produce the marijuana plants. Tier 2, they could grow indoor or outdoor, no more than 10,000 square feet canopy. Tier 3, indoor only, not more than 25,000 square feet. Tier 4, indoor only, no more than 45,000. And Tier 5, the largest one, indoor only, and not more than 70,000 square feet. Also, just to note that a secure agricultural greenhouse, which is defined in the bill, is considered indoor cultivation and is permitted as long as it's surrounded by a fence that's at least 8 feet tall. The next type of license is a processing facility license. So this would be for producing marijuana products or blending, infusing, compounding, or other preparation of marijuana. Then there's a retail marijuana store license. That's for selling marijuana or marijuana products at retail to consumers. And then there's the transporter license, which would be for taking possession of marijuana from another licensee and transporting it between licensees. And then there's the testing facility license, which would be to develop, research, or test the products. The board is to promulgate regulations that limit the number of each of these licenses, but the bill does specify that the numbers are not to exceed certain amounts. So for retail marijuana stores, it's 350. For processing facilities, 100. Cultivation, it's a total of 125, 50 tier 1, 50 tier 2, 10 tier 3, 5 tier 4, and 10 tier 5. And the testing facilities, the maximum is to be set by board regulation. Just to note that the 6th enactment clause also did include that the CCA would be required to analyze whether any limits should be placed on the number of license and to analyze the canopy limits for cultivation facilities and report those findings to the General Assembly. There are also limitations on multiple licenses awarded to a person. No one can have more than 5 total licenses, not including a transporter license. You can't hold more than one of the Tier 5, the largest cultivation facility license, and no one who has a cultivation facility, processing, transporter, or retail can have a testing facility license. The bill also provides some provisions for pharmaceutical processors and some industrial hemp growers and processors who are already licensed or permitted. It states in the 4th enactment clause that between September 1st, 2025, which in the bill would be when the CCA could start accepting applications for licenses, and 2030, the CCA would need to reserve license lots for all permitted pharmaceutical processors and cannabis dispensing facilities and issue applicable licenses for any of their locations, provided that the licensing requirements are all met. And then it also notes that there would be priority for the 2 biggest cultivation facility licenses to be given to permitted pharmaceutical processors and no less than 5 registered industrial hemp growers or processors that completed that registration prior to a certain date. The bill also grants the CCA board has the duty.
Taylor, let me just interrupt.
Yes.
Give you a second to compose yourself. But the dates that you see on there, remember, these are the dates in this bill. So this is a bill that was introduced, last year. So obviously a future bill would not use the same dates, so you don't think that September is really coming up pretty quickly.
Yes, that is correct. I think we have a big red note on the last slide about the timeline, but that's good to reiterate that these would have been the dates had the bills this past year passed, and they did not pass. So the CCA board has the duty to grant, suspend, restrict, revoke, or refuse to grant licenses. There are certain sections that lay out the conditions under which the board shall or may refuse to grant licenses. I've just noted a few. This isn't an exhaustive list, but they may refuse if there's reasonable cause to believe that it would be detrimental to the interest, moral, safety, or welfare of the public. They shall refuse under certain conditions that are laid out in the section noted, some of those being, for example, if the applicant's under 21, or if the applicant had been convicted of a felony or a crime involving moral turpitude within the previous 7 years, or if the place to be occupied by the licensee doesn't meet certain conditions, and those are also laid out in that section. There's also grounds for when the board may suspend or revoke a license that has been granted. Some of those may be that within the previous 5 years, they committed certain violations of the subtitle or regulations of the board, or if they've been convicted of a new felony or a crime of moral turpitude. There's also certain grounds for when the board has to suspend or revoke a license that's been granted. Some of those are reasons related to illegal possession of a gambling device at the store, at a retail store, or they've defrauded the board in some way. The board is also to come up with regulations that establish an application process for licensure as any of these marijuana establishments in a way that prevents disparate impacts on historically, economically disadvantaged communities. And applications for any of these license types will be filed with the board. And the section includes certain requirements for publication of an application, notice, certain background investigations, and fees. One note that in considering criminal history record information, it does note that the board shall not disqualify an applicant because of a past conviction for a marijuana-related offense. And I believe I'm turning it over to Stephen now to go into some of the tax provisions, revenue, social equity, and local authority.
Hello. Here, it's working. All right, thank you, Mr. Chair. I am going to touch on first the license fees. So the license fees are going to be established by the board in an amount sufficient to cover regulation of these marijuana businesses. That would apply for all of these different types of licenses, but do note that the precise license fee amounts are not specified in the bill and would be left to the discretion of the board. Licenses would ordinarily be issued for 12, 24, or 36-month terms, but a 5% fee premium could be charged to licensees for a different licensing period. I would also highlight Enactment Clause 8, providing that in the first year, 75% of all license fees collected will be directed to the Cannabis Equity Business Loan Fund that I will touch upon later. But as a result of that redistribution of license fee revenues in the first year, the FIS notes that the authority would not have had enough non-general fund revenue to fully fund the regulatory program in that first year. Therefore, we would have required general fund support. However, that would have been a one-time redirection of the license fee funding, and in subsequent years, the adult use program would be fully funded by the licensing fee revenues. Prior year's legislation made reference to a social equity license applicant, but the 2025 bills instead defined a micro business as one having at least 66% ownership and direct control by someone who meets at least one of 6 criteria categories on the slide here. So you just need to meet one of those 6 to qualify, but if you meet more than one, you would move up the priority list as far as the applicant pool goes. If you are a micro business, you are eligible for a number of preferences and priorities. So you get preference in the licensing process itself, eligibility for partial application and license fee waivers, and less stringent licensing and regulatory requirements. Turning to taxes and revenue distributions under the bill, on the state tax front, there is an 8% marijuana tax on the sale of marijuana, marijuana products, and marijuana paraphernalia, with exceptions for sales between marijuana establishments, sales for treatment under the medical program, certain industrial hemp sales, and sales of a hemp product. There is also a 1.125% sales and use tax rate. Note that is lower than our normal sales and use tax rate because it is capped under the bill and has a specific distribution that I will get to later. Finally, the bill also allows licensees to claim income tax deductions for marijuana business expenses on the state tax returns, something that several other states have done. For some quick background on that piece, federal law generally prohibits tax deductions for any amount paid or incurred in carrying on a trade or business if that trade or business or the activities comprising it consists of trafficking in controlled substances, of which marijuana is under federal law currently. So this federal prohibition includes even states where marijuana is legal. So because the Virginia tax code currently conforms to that portion of the federal IRC, this bill deconforms from the federal prohibition and allows CCA licensed marijuana businesses to deduct their ordinary business expenses on the Virginia state tax return. The bill also provides localities with the option to impose an additional 2.5% tax on sales of marijuana products by ordinance. Note that while some legislation authorizes a local tax rate up to a certain percentage, these bills would have required the local tax to be equal to 2.5%, not up to. This optional local 2.5% tax, once imposed by ordinance, is irrevocable, and any revenues from the local tax would all be returned to the local coffers for use as the respective locality sees fit. So where does the money go? Before I dive into this, please note that Enactment 10 in the bills would have provided for a delayed effective date of the changes to the revenue distribution. So as you see, until July 1st, 2027, and keep in mind retail sales beginning under the bill May 2026, until July 1st, 2027, in that first year, we would have kept current law as far as the revenue distribution goes. So it would have been 40% for pre-K programs for at-risk 3- and 4-year-olds, 30% to the Cannabis Equity Reinvestment Fund, 25% for substance use disorder prevention and treatment programs, and 5% for public health. Once that enactment clause ends and we kick in the changes to code from the bill, the distribution changes. Substance use disorder prevention and treatment and public health programs stay the same at 25% and 5% respectively, but the split between pre-K and the Cannabis Equity Program changes pretty drastically from 40-30 to 10-60, as you see there. The state sales tax at 1.125%, we would dedicate 1% of that to public education based on school-age population and 0.125% of that for the state SOQ payments, and just noting that it would be 1.115%, taking into account the 0.01% dealer discount that marijuana businesses would be able to collect as compensation for collecting the taxes on behalf of the state. And then finally, again, the 2.5% optional local tax.
So the total is 11.625%. unless the local government does not do the 2.5%.
Correct, Mr. Chair. So this slide is directly from the FISC, kind of breaking down everything I just mentioned. The Department of Taxation utilized the mid-range point of JLARC's 2020 report numbers to calculate the estimates you see here, only accounting for revenues generated by the 8% marijuana tax and the 1.125% state sales tax. The Commonwealth could generate state revenues in amounts of $1.25 million in the first fiscal year, $15 million in the second, $30.6 million in the third, $47 million in the fourth, $61 million in the fifth, and over $74 million in the sixth fiscal year after the bill becomes effective. The slide also breaks down the marijuana tax distribution I just mentioned and the sales and use tax distribution, and the footnotes at the bottom kind of break down those effective dates based on the enactments as well.
But this doesn't include the license, the amount of money that would be generated by which we don't know what the numbers are anyway because.
Correct, Mr. Chair. Okay, so returning to that revenue distribution briefly, you recall how the bills increased the revenues directed to that Cannabis Equity Reinvestment Fund beginning in fiscal year 2028. I just wanted to highlight the allowable uses of that money, and the code says that that money shall only be used for purposes of supporting persons, families, and communities historically and disproportionately targeted and affected by drug enforcement, providing scholarship opportunities and educational and vocational resources for those historically marginalized persons adversely impacted by substance use, awarding grants to support workforce development, contributing to the Virginia Indigent Defense Commission, and contributing to the Virginia Cannabis Equity Business Loan Fund, which makes grants and low to zero interest loans to these micro business licensees in order to foster business ownership and economic growth within communities most impacted by prior marijuana prohibition in the Commonwealth. To get away from numbers now and get into local authority. So as we discussed, localities do have that option to impose the 2.5% additional tax on marijuana sales by ordinance. The bill also authorizes localities to hold a referendum on the question of whether retail marijuana stores should be prohibited in the locality. The referendum is not required. It is only required if a locality wants to prohibit retail marijuana stores from operating within its boundaries. So the default for localities who do not hold a referendum would allow for retail stores to operate. Enactment 9 in the bill, though, requires that a first referendum be held by December 31st of 2025, or localities would then forfeit the power to hold a prohibition referendum evermore. If the prohibition referendum fails, retail marijuana stores would be allowed to operate within 60 days of vote certification, and no subsequent referendum would be allowed. So once a locality votes to not prohibit retail stores at the referendum, they cannot hold another referendum to prohibit it. On the other hand, if the prohibition referendum succeeds, so they say we are prohibiting stores in the locality, then retail stores would be prohibited from operating beginning January 1st of the year following referendum. However, in this scenario, the locality would have to wait 4 years and could hold another referendum on the question to later on allow retail stores to operate there. Finally, a few points on the local regulatory authority. Localities are authorized in the bill to prohibit and penalize consumption of marijuana in public places, certainly parks, playgrounds, streets. Localities may still impose and enforce local business regulations, including zoning, land use requirements, and business license requirements. And they may also regulate the time of sale and say you can only buy marijuana between certain hours.
Senator Abbott has a quick question.
Stephen, I wanted to ask you a little bit about the prohibiting and penalizing consumption in public. It was my understanding that in 2021, we imposed a really weak penalty for public consumption, which was like a $25 fine. And I was wondering if the locality wanted to prohibit consumption in public in those kinds of areas, is there an additional fee or is it just a local ordinance?
I do know it, Mr. Chair, Senator Evan, I do know it's done by local ordinance if they were to govern that. Governing body of any county, city, or town may adopt an ordinance prohibiting in its local public parks, playgrounds, public streets, or any sidewalk adjoining any public street the acts described basically in this bill, and may provide a penalty for violation thereof. So it doesn't specify what that penalty might be, at least in this bill. I'd have to double check on what the 2021 legislation held.
Mr. Chairman, I would ask for a future meeting to let us know what our options would be in terms of a local public penalty, because I think it's important that children and people on the street are not exposed to cannabis smoke. And I got Mr. Shuford from the CCA gave me a quick rundown of what some other states do with public consumption, and it appears that our current law is among the weakest in the country. And I noticed that in Colorado, they allow for, in addition to fines, to be sentenced to community service for public use. And I'm all for discouraging it. I don't want to recriminalize entire communities. But for members of the panel, I think it's important that we discourage public use. I think that localities would be more likely to authorize the sale if they knew that they weren't going to have like a chimney of marijuana smoke on certain areas in their city. So just something that we could consider and maybe compare those penalties at a future meeting.
Okay, duly noted. We got a lot of future meeting stuff.
All right, Mr. Chair, if there are no further questions for me, I'll turn it back to Taylor to conclude.
Yeah, but to be clear, this bill would allow the localities to have the flexibility to institute whatever fine they want.
Yes, Mr. Chair.
Thank you.
Thank you, Mr. Chair. And this is the last slide, we promise. But just briefly touching on Senator Ebbins' question, I just wanted to note, I don't know if this is along the lines of what you're asking, but there still will be a code section in Title 4.1 that deals with using or consuming marijuana in public, and it is still the up to $25 civil penalty. I think there's a few graduated penalties if it's like a second or third, and I think Troy's given me those right here, and then there's a separate one for consuming or possessing on school grounds, but those will all still be laid out. I think it does still allow localities to have a local ordinance dealing maybe more specifically with certain parks and whatnot, but just wanted to point out that that's still in the code, that you can't consume in public. That will still be laid out in the bill and in current law. Okay, now for the last slide, this is just briefly goes over what the timeline and effective dates would have been in the bills from last session that did not pass. So these dates will not be happening, but this is how it would have been laid out in the bills from this past session. So it would have laid out that on September 1st, 2025, that's when the CCA could begin accepting applications for licenses. And then between that time, September 1st, 2025 and May 1st, 2026, the licensees could operate, but they couldn't engage in any retail sale of marijuana yet. Then by December 31st, 2025, the CCA would need to have the seed-to-sale tracking system established, promulgate all the regulations to implement the act. As Stephen mentioned, that initial local referendum would need to be held and certified. And then by May 1st, 2026, that's when retail sales would begin. So along the same lines, the effective dates in the bill on July 1st, 2025, that's when all of the sections setting up the licenses would have gone into effect. And then not May 1st, 2026, that's when it would have repealed all the current crimes related to sale of marijuana and all that sections with the cross-references, since that's when retail sales could begin.
Thank you. Do we have any questions or comments from the commission before we go to the next presentation from the CCA? And I think the easy thing to do on that timeline is just add a 1 to everything. Yeah. So if you think about, it would be 2026 instead of 2025. Any other? No? All right. Let's bring up our Jake Shuford from the Virginia Cannabis Control Authority. And I want to thank you for that very detailed report. Thank you. Everybody was we learned a lot, and I think the public did too. And then what I would urge the public to do, and that everybody in the room as well as those online, is to take some time to go through the bills and mark it up and what you like, what you don't like, and come back to us and let us know. All right, Jake. Yes, and Delegate Price.
Yes, and just because words matter, the bills did pass. They just weren't signed. Okay.
Thank you, Mr. Chair. Delegate Price.
Good afternoon, Mr. Chairman, members of the Commission. Jake Schufer with the Cannabis Control Authority. First and foremost, I want to thank you for your time and your attention to this matter. It's a large undertaking establishing a new industry in the Commonwealth, and the CCA looks forward to working with you all. Taylor, Troy, and Stephen did an amazing job covering all the laws. I will maybe touch on a little bit of what they already spoke to, but I will keep this very, very brief and provide an overview of the CCA and the current status of the medical cannabis program. The CCA is an independent political subdivision of the Commonwealth. We really look at everything through a public health and safety lens, and we fulfill about three main roles, which is as regulator, policy advisor, and educator. History of the CCA, which was covered previously, was legislation established the CCA in 2021, and we started hiring staff in 2022. And then on January 1st of 2024, the medical cannabis program transitioned from the Board of Pharmacy to the CCA. As I mentioned, our roles fall into a few categories, including regulator, which is currently we only regulate the medical cannabis program. We also serve as a policy advisor to you all. We are always open and welcome to meet with you and discuss any issue, any constituent issue, or anything at all. We truly are a resource for you all and for the Virginians. We also take pride in our educator role. We have created dozens of resources, educational materials for the public, for other state agencies, working groups, we collaborate with as many groups as possible to help educate the public about cannabis. As I mentioned, Taylor, Troy, and Stephen did a great job already covering the laws. I will be very brief here. What is legal is medical cannabis, limited home cultivation, limited possession, and limited adult sharing. I'll go into each of those in a little bit more detail. Home cultivation is 4 plants per address in your private residence. The plants do have to be labeled. It's a relatively simple label, nothing too extreme. And the plants cannot be visible for the public, and they do have to take steps to prevent access by minors. For possession and adult sharing, I will note that this is for an adult use market. There are individuals under the age of 21.
Hold on a sec. I'm sorry. Senator Craig.
Thank you. Just a quick question. 4 plants per household. If you own 3 houses, do you get 12, or is it just per location, per your primary residence?
It is your primary private residence.
Are you sure? Is that correct? Okay, so if you own a beach house or something like that, of course the plants would die because you wouldn't be there enough to water them anyway. All right, thank you.
There is limited possession for adults 21 plus. You can possess up to 1 ounce in public, and you can also share up to 1 ounce privately with other adults. And I will quickly note that the medical cannabis patients do not have to be 21. They are allowed to be under the age of 21 if other conditions are met. Again, covered previously, but an overview of cannabis tax. Medical cannabis is exempt from the sales and use tax currently. And then the tax that was proposed in legislation from 2024 and 2025, you can see on the slide and was covered previously. Hemp was also discussed. I won't go into great detail, and that is regulated by Virginia Department of Agriculture. And you can see we have the 25-to-1 ratio or less than 2 milligrams THC. What's illegal is very much the opposite of what is legal. I will note that many people don't realize that landlords still have the ability to prohibit certain things: possession, consumption, plant growing, and then there's also elements of travel, which I'm not sure a ton of people are aware of, but you are limited in some respects when traveling with cannabis. As for the medical cannabis program, we have 5 pharmaceutical processors permitted. As discussed, that one is a conditional award a conditional permit has been awarded. And I will also note that there is pending litigation regarding that conditional award ongoing currently. As far as patients, the requirements you can see on this slide, they do have to be a temporary resident of Virginia and have to have a written certification from a licensed practitioner and provide proper paperwork when at a dispensary. This slide has an overview with a map that you can see where the current dispensaries are located, as well as the types of facilities listed there. A few numbers that I'll share with you here. Unique patients, we have over 100,000 as of last year. You can see the breakdown on the monthly spending that the average patient typically has for cannabis, as well as the products that are most often purchased.
Yes, Senator Evans.
Yeah, Jake, can I ask, how does that compare with other states that have medical cannabis? 104,000 medical unique patients in a state of about 8-point-something million people. Is that less than other states or similar?
Mr. Chairman, Senator Eben, I don't have a concise answer for you. I think it does vary widely from state to state, depending on the laws. Obviously, where it is adult use is allowed, we typically see a decline in the number of medical patients. Obviously, where there is no recreational market, you typically see a slightly higher number. I think Virginia is, I would say, probably fairly similar with these numbers to other states who are in a similar situation. I can certainly look into that more and provide you with actual numbers.
Yeah, Mr. Chairman, that would be helpful, especially on a per capita basis with some of the states that have limited outlets like we do, or just in general, to get a sense if we're meeting demand or if there's need for more outlets.
Absolutely. I'm happy to look into that for you, Senator.
Thank you.
The CCA did conduct a patient satisfaction survey in 2024. You can see here some of the information that we captured, including typical cannabis use, the process of attaining their written certification, purchase behaviors, and their experience with the dispensaries. I wanted to show you this slide just so you have an idea of what the written certifications are often provided for. The 3 main conditions are anxiety, depression, and chronic pain. I'll also note the 4th largest section there is an alternative to opioid use for pain. One other thing I wanted to talk about was the seed-to-sale tracking. Virginia's seed-to-sale tracking system went live July 1st of this year, so very recently. We're very excited about this. This is a system that will allow us to, very much as the name says, track cannabis plants from seed or clone all the way through the process of cultivation, harvesting, processing, and sale to individuals. This is an invaluable system that's going to really provide a lot of data to us and allow us to make more informed decisions going forward. And when an adult use market is in place and we have hundreds more licensees, it will be a very helpful system to make sure that there is no diversion of products to the illicit market or illicit products entering the regulated market. It's a system that's used by just about every jurisdiction that has cannabis, either medical or adult use, and we are excited for the data that it's going to provide us.
Is it too early to ask you to share any of the top-line data that you've...
I've got the top line for you. Unfortunately, that's all I have. But from July 1st to July 8th, there was 3.9 million in sales. I'm sorry.
The dates, so it's July 1st through July 9th, 3.9 million, and that's overall all the whole Commonwealth, all 5 licensees.
July 8th. Today is
July 8th.
captured.
I'm sorry. July 8th. And why? And we just talked about the bill that I introduced last year, and we mentioned that we would go seed to sale by the October after the bill was signed into law, after the law went into effect in July. Is that, and this is really perhaps a question better asked later, but I'll just throw it out there. Is that something that the CCA could meet? And I guess the second part of the question is why did it happen now with the medical at July 1 and not earlier or later, for that matter?
Mr. Chairman, I would of course love to consult with my other team members at the CCA before providing any exact dates. I do feel confident that we could meet the date from the previous legislation for an adult use market. This, like I said, is a system that is used by every jurisdiction with cannabis. It has been a bit of a process implementing it because we have to build it out on the back end for our specific needs. It's been an ongoing process at the CCA for quite a while now, and we're working very closely with our pharmaceutical processors to ensure that it's as seamless as possible transition. So this has been something that we've been working on for a very long time, and it really is now just only coming fully with a completed product that we can use and start working with the processors to implement.
And I would assume that having it now would be very helpful for us. Yeah, okay.
Yes, sir. Having it now is very helpful going forward for an adult use market.
So is my math correct in saying it's around 500,000 a day so far, seed to sale? Is that more or less? Okay.
More or less, yes, sir.
Thank you.
I will now briefly touch on some of the data initiatives. We've obviously already conducted the medical cannabis patient survey and collected a lot of data from that, and we have the seed to sale tracking system, which will provide us more data going forward. But some of the things that we've already been working on, in addition to data collection, are educational resources, which I mentioned we have dozens of. A safe driving campaign, which was in the, I believe, the 2021 legislation. And so that's something that I'll touch on a little bit more later. And then generally partnerships and outreach is something that we like to do as much as possible. As far as educational resources, there's just a few here on this slide. We have many more. We cover broad issues such as the laws in Virginia regarding cannabis and more niche topics such as high potency THC, pop-up shops, and things like that. We encourage you all to check out our resources on our website, and I'm more than happy to provide any to you. And we also provide these resources to other agencies, other working groups, other community partners, and we've had many bulk orders distributed already. I don't have a number, but we've distributed, I would say, thousands and thousands of resources to the community.
Delegate Price.
Yes, thank you. Under the educational resources that you have listed, where you have the health risks, do you also talk about the health benefits, or is it just from the risk perspective?
That's a good question, Delegate Price. I believe we do talk about some of the health benefits. However, that was, I believe, not the focus of some of the materials. I will double check and I will follow up, and I will be happy to send you the materials that we have related to both health risk and health benefits.
Follow up.
Yep, Mr. Chair. So then if you were able to go back and see that if they were all coming from the health risk perspective and not as inclusive on some of the benefits, what would be the process of either updating that information, or is that a conversation we need to have for a future meeting? But like, how would that decision get made? What would be the proper channels?
Mr. Chairman, Delegate Price, I think your question is probably more than enough to spur me to go back to my team and express your desire to have these things covered, and we can work on that immediately.
Thank you. Well, we're all going to spend some time looking at this material too. I see you've got a bulk order form here. Will that also take us to the web page so we don't want to order them in bulk. Can we just get one or two?
They're all on our website.
Okay.
We have them organized there by topic so that hopefully it's easy for navigation. And like I said, I'm also happy to provide physical copies or email them to you directly. To be honest, I'm not entirely sure where that QR code leads. I should have checked that. I apologize.
It's a form. All right. Thank you. It's an order form. Everybody can get this. It's free.
So can you just want to tell them to email it to us?
Yeah, just email it to
Can we
us.
go on and request at least the email for the commission, and then that way we'll know what we're working with? Thank you.
Absolutely, happy to.
Thank you, Delegate Price. All right, Jake.
One topic that I did want to discuss in a little bit of detail is our impaired driving survey. Again, we feel this goes hand in hand with our safe driving campaign and is an important undertaking for the Commonwealth. You can see some of the metrics of the survey on this slide, and I will go over a couple of the key takeaways, including that about almost one third, or 30% of Virginians believe that it is actually safer to drive under after consuming cannabis. That was a bit of alarming discovery from this survey. And I'll say that it's not too unlike what we've seen historically with alcohol, and it will involve a prolonged public education campaign to change those perceptions. And that's something that we're very aware of and are working on diligently.
That is disturbing.
And for comparison levels, here you have a few other dangerous behaviors and how, from our survey, how people rank these from extremely dangerous to not at all dangerous. And you can see there that driving after using marijuana falls below things like texting while driving on a danger scale for a large portion of the the surveyed.
Delegate Carlson.
Thank you, Chair Krizak. I have a question. So this is the perceptions that Virginians have, but do you have facts to combat that? Like, do you have facts that show that it is more dangerous, less dangerous?
Unfortunately, Mr. Chairman, Delegate Carlson, unfortunately, I don't think there is enough data collection happening. We honestly don't have really good data about individuals who are being pulled over or involved in accidents. Collection of the data as to if they actually were impaired. We don't have enough of that data. I can't really speak to the dangers of driving while texting or others. Obviously, we know they're dangerous. We would love to see more data collected regarding impaired driving, and that's something that we hope to work with and partner with law enforcement to get better reporting in that regard.
Thank you. I think we all share that concern, and we'll help you with support. Delegate Carlson, do you want to follow up?
Zach, yes, one quick, I guess for a future meeting, add it to the list. That would be important to me, even if it doesn't have to be data drawn from the field. I imagine there's got to be some kind of scientific study somewhere in a lab. I'm sure there are many willing participants who are willing to run some tests, but it's always good to have laws based on facts, and I'm curious. Thank you.
Thank you. Delegate Price.
Yes, and while we're sitting here, I've received a link, and it seems that Normal has a scientific study that we can share with the commission, and then should the chair see fit, maybe add that for review on the website as well.
Yeah, the clerk can put that, we can get that to the clerk and she can put it up. Correct, thank you. Good catch and good information, but go ahead.
I will briefly say that there are green labs, as they're known, which are similar to the alcohol wet labs, where they, in the alcohol ones, they take individuals when they're sober, test them on a closed course, provide them with alcohol, see the results. They are doing that with cannabis in a few locations, typically in other states. I don't know that there may have been one recently in Virginia. Someone else can maybe speak to that. It wasn't run by a state agency that I'm aware of, but I know that Maryland has done these, as well as Colorado and some other jurisdictions. And again, unfortunately, there is not necessarily a clear answer coming out of these scientific studies. It does seem that different individuals are impaired by THC in different ways and at different levels. There's still a lot more scientific research that needs to be done. But it is something that we are watching closely and that is beginning to become more prominent in the cannabis sector, is to really see, conduct these studies and see how it affects people behind the wheel.
We'll reach out to outside experts for a briefing at a subsequent meeting. I think this is an important, obviously very important subject. All right, Jake, continue on. Sorry for interrupting.
As mentioned, the 2021 legislation required that we conduct a safe driving campaign. Our first phase of our campaign ran from 2022 to 2024, and that included billboards, TV, radio, social media. We tried to reach out and connect with people wherever we could. And we do have an RFP in progress for the next phase of our safe driving campaign. And you can all look forward to that. Last few things I want to touch on are some of the partnerships and outreach. I've mentioned this previously with our educational resources and our data collection. We do really view ourselves as a resource for you all and for all Virginians. We hope to work with as many community groups and other agencies and interested partners to provide them with whatever support they need and any resources or research that we can provide for them. And with that, I am done with my slides. I am open to questions. And I've provided some contact information here, so you're more than welcome to reach out to us at any point in time. We really do hope that you will come to us with any issues, and we can serve you all as you look to draft this legislation.
Thank you, Jake. Good presentation, lots of information. I will note that the copies that you gave to us don't actually have all the slides in them, so we'll have to get new copies for those that want them. Otherwise, we can get them online, and we can make them available on the website too for the general public.
I can include it when I email the educational resources.
They're on now. Thank you. Any further questions? Any comments? Delegate Fowler.
Excuse me, with the mic on, excuse me. I have a question. If we could go back to this bill or the local authority, I have a question. And one of the questions I have is we're working here off apparently House Bill 2485 and Senate Bill 970. Neither of these bills passed the legislature. Well, I thought the governor vetoed them. What's that? Excuse me.
Yeah, Delegate Fowler, what we say, they passed, we voted for them. In fact, you did. And I appreciate your vote. I
didn't vote for them, but anyway.
But in the committee, let's.
Yeah.
And then we passed it through the House and the Senate, and it went to the governor, and the governor vetoed. That's the status of the bills. Yeah. So when we say, so it's not legislation. You're correct in that respect. Do you have any other further comment?
Let me ask you another question. So we got an enactment clause here that says you have to hold an initial referendum by December 31st of this year or forfeit prohibition referendum power. Is that correct?
Well, remember the dates you have to add a year. So this will be next year.
Okay.
If the bill passes and in this form, I mean, there's a lot of hypotheticals. Here's the hypothetical. If the bill passes as we've outlined it in this form, we do nothing to it, and the Senate passes the House, the Senate, it goes to the governor, and whoever the new governor is signs it, then yes, it would be next. It would be 26, right? It would be the end of 26. Yeah.
Well, thank you, Mr. Chairman. But like I say, the literature before me said 2025, so but now we're clear on it. So thank you, sir.
Right. The reason it says 25 is because it's talking about the old bill and it's using the old dates. But the new date, yeah, I knew that would be a confusion because it is confusing. So I thank you for bringing it forward. Any other questions or comments? All right. Thank you very much. It's good to hear from the CCA. And that you're busy now, especially with the sale data collection. All right, that leads us to our last, our penultimate agenda item, which is the public comment. And so what we have is we have 30 minutes for public comment. We'll do this at every meeting, so if you feel like you didn't get enough time, you'll have an opportunity next time. I do ask that everybody exercises decorum and is respectful of each other. And respectful of the time. And so depending on how many people, I think the thing would be for folks to line up. We do have people signed up also online. And I think most of those people are online, but maybe some of them are here. But if you will come to the microphone or line up towards the mic and come up to the mic and introduce yourself, and you have 3 minutes, but we'll give you enough time to make any public comment. And if it looks like there's not that many people, then you'll have more time. All right. All right, the clerks put, okay, there, you see the 30 minutes is up there. All right. Please introduce yourself and your organization. Thank you.
Good afternoon to the chair and to the commission. Thanks so much for your efforts here. My name is Chelsea Higgs-Wise. I live in the 77th House District, and I also run marijuana justice with the Canada Justice Coalition. Many of my remarks today are in response to what we've heard today, and also just want to continue to offer our support for any information that is needed regarding what's happening here in Virginia as well as across the country. Was really excited to hear our folks talk about the 2020 JLARC study, and so I just wanted to also lift other points from the JLARC study that was also mentioned. Just continuing to support the Cannabis Control Authority, as when we talked about putting it under the ABC, that it would actually create more or less benefits than if we had our CCA. The only benefit was that with ABC that it would be faster. So continuing to support the CCA. In 2020, JLARC also stated that urgency is not in our best interest, and even quoted many Illinois legislators that said they wish they had slowed down. So as we move forward with creating our legislation and our regulations, that it's okay to take our time and make sure that we're doing this the right way. The JLARC 2020 also stated that in order for that equity loan to be funded in the first and second year, that it should come from existing funds. So a capital loan from Virginia to Virginia that would be repaid, and that tax revenue is written out in that JLARC report. In past bills, that has actually been leveraged for possibly other bigger entities in cannabis to come in first with transitional or early sales. We can actually just use these recommendations from JLARC to do that. I also just want to make sure that we understand that we want to make sure that our stores are around the 350, and what that can mean if we allow for certain operators to hold multi-licenses under one license, and just see that those are certain exceptions that we are allowing that could possibly not be exceptions for maybe some of our small businesses and farmers. I just want to really also share that we have many connections to experts across the country. So we don't have to feel like we have to learn our lessons on our own or the hard way. So I think it's going to be really important that we look at what's happening across the state. It was also mentioned across the country. It was also mentioned about public consumption. I just want to urge this body, before we make any more recommendations to criminalizing public consumption, to remember that, number one, people that live in public housing cannot consume anyway. It's completely federally prohibited. Most states that ramp up their public consumption laws, it targets people that are homeless, houseless, and very poor. And just again, remembering that landlords can prohibit that, and we are not or we have not yet really discussed consumption lounges or consumption spaces that offer that alternative space for consuming when you're not allowed to consume in your home. So we're basically criminalizing that if they have nowhere to smoke or consume in their home, nor anywhere to do that outside of their home. We talked at length as well about the benefits, and really appreciate the question from Delegate Price about the campaigns and what they focus on. We are connected to Dr. Jane Allen, who actually helped with the Truth Campaign with tobacco. And she would be more than happy to help also recommend other pieces about how this campaign can really be a public health conscious campaign. My name is Chelsea Higgs-Wise. Again, really happy that this commission is meeting, and thank you all for your work.
Thank you, Chelsea. I want to just comment quickly that you've mentioned some really good resources. If you could get a list of some of those to us. But number one, the JLARC study that you referenced, all the commissioners should reread that. I know, refresh yourself with that, because it's old, it's 5 years old, but it's still very applicable, and they did a lot of good hard work. I'll also mention, I should have mentioned this earlier, it's the Crime Commission on August 19th is going to be hearing presentations on impaired driving, and they're going to have DFS and DMV are going to present, and they're going to try to get somebody from Maryland there and to talk about their Green Lab program. So anyway, and maybe I'm sure CCA will probably be invited to testify too. But there's some good resources going on right now, but there's some good stuff that you have given us, and so thank you very much for that.
Of course, in the JLARC chapter is chapter 11, and I'll also just mention there is a line in this current bill from 2025 that says any technology that is passed for roadside driving and says it's approved will be allowed for cannabis. I want to just caution the commission on that, because roadside testing is actually the #1 reason for false arrests, and that many of these technologies are proven to be unconstitutional and give false results. So as we talk about drug driving, we're not saying it's not a problem, but we're saying that maybe the technology that's being rushed out there is also not the answer. So thank you.
Thank you. Thank you. All right. We have 26 minutes, so we have plenty of time, but there's also folks online.
Good afternoon, Chair and Commissioner. My name is Jewel Gatling. I am a resident of Richmond, Virginia. Thank you for the opportunity to speak to you all as a Marijuana Justice Board member. I am here to provide a friendly reminder of the 2020 JLARC key considerations for marijuana legalization that provided guidance for legalization and regulation for fair and equitable cannabis industry. Even after the report was public and presented, in 2021, a bill was sent down from the administration that didn't just miss a few points of the JLARC recommendations. It moved miles away from the spirit of the report. So the people fought back. We highlighted sections of the report to create the Cannabis Control Authority. Rather than copying and pasting the ABC law to allow an agency meant to oversee alcohol the power to regulate a completely different substance it knows nothing about. It was because the voters put pressure on legislators that members were finally able to take its own research agency's advice. So we hope that the commission will learn from the past, save us some energy, and do what's right. For the last 4 years, we've been unable to openly discuss the best models for Virginia. So there's a lot of catching up for us to do, but you all are up for the challenge. This is not a time to rely on what we did under an oppressive administration, but to remember, we voted you in to do what's possible, not what's easy. Thank you for your time, and we look forward to working with you all. Thank you.
Thank you.
Good afternoon, Chair, Vice Chair. My name is Jason Blanchette. I am the president of the Virginia Cannabis Association. Didn't actually think I'd find myself up here today, but here we are. Been coaxed into it, so I want to thank all of your efforts here. I do want to thank Delegate Price. Not only is she from Newport News, and I have a business in Newport News, but words do matter. And this bill, the current form of this bill, has passed twice. It's just been vetoed twice by the governor. So obviously our hope in representing small Virginia businesses and small farmers, along with the stakeholders behind me, which I'm sure we can all come to agreement at some point here, right? And so we just want to thank you for doing this. And if we can be a resource, just let us know. And thank you so much.
Thank you, Jason.
Good afternoon, everybody. I'm here to just introduce myself as well as speak about why I'm here. My name is Thelonious Cook. I'm a small farmer, owner and operator of Mighty Thundercloud Edible Forest, located on the Eastern Shore in Northampton County. I practice regenerative and sustainable methods. Apart from that, I'm also president of the Mid-Atlantic Black Farmers Caucus, and we are a collaborative network of Black farmers spread throughout not only Virginia, but neighboring states of Maryland, D.C., Delaware, and southern Pennsylvania. And we're cooperating and collaborating together to increase access to locally produced food, nutrient-dense, culturally appropriate food, and other agricultural products. So we are addressing food and nutrition security. We do believe that food is medicine. And so I'm here to represent the voice of small farmers, and in particular, Black farmers, who we know, had it not been for the enslaved labor of Africans producing tobacco on the plantations of Virginia, this colony would have not survived, let alone, go on to become America. So, so we want to make sure that we have opportunity to participate in this agricultural revolution in a way that we weren't able to during the tobacco and cotton phases. So I'm here to represent their voice and make myself available, to this commission. Thank you.
Thank you.
Good evening, everyone. My name is Lonnie Hayes. I reside in Stafford, Virginia. I've been blessed with the opportunity to be Virginia State Director for a national nonprofit called Minorities for Medical Marijuana. I just wanted to make myself present and the organization present. We're working with people and organizations in Virginia like THC Justice Now, Chelsea Higgs, and lobbyists, Richmond Crusade for Voters, and looking to connect with any of the other people and organizations at the CCA. We'll reach out to Jake and look forward to promoting safer cannabis use for Virginians. Thank you.
Thank you, Lonnie.
Hello, my name's, excuse me, my name's Mary Lynn Mathry. I'm a registered nurse, president and co-founder of Patients Out of Time. Patients Out of Time is celebrating its 30th anniversary this year. We're a 501c3 Virginia-based nonprofit dedicated to educating healthcare professionals and the public about the therapeutic use of cannabis and about the endocannabinoid system. So I want you all to know you have the perfect opportunity coming up. In Charlottesville, September 14th to 16th, we'll be holding the 16th National Clinical Conference on Cannabis Therapeutics at the Forum Hotel. Literally, we are the leading accredited conference series on cannabis, started in 1995. Unfortunately, it took us 5 years to find someone who would accredit the conference because no one wanted to talk about cannabis. But anyway, we have persevered to persevere. The conference will open with, we've got 2 pre-conference workshops by Oaksterdam University, and for those who don't know, they're probably the leading educational organization for teaching people how to grow, and specifically for patients who need access to their medicine. They'll be having a course on horticulture, how to grow cannabis, as well as safe products. And as a nurse, that to me is the big issue here in Virginia. Whatever the law goes, please don't do the high taxes. That just puts people to stay back in the black market. It gets so expensive, they're not going to go there. But the labeling has been terrible. I've seen products that 500 milligrams of cannabis in a single chocolate bar. It's ridiculous, and does cause harm to patients. But anyway, I just I had to put that plug out. The education opportunity is here. We have been the leading throughout the United States. We've got Dedi Miri coming from Israel. We've got Stacy Gruber coming from Harvard. If you've got concerns, we address the concerns. We do have great concerns. This is a plant that has been around forever and ever. I hope you don't think that you have to make all these guardrails about it. It can't hurt anybody. The natural plant literally cannot hurt anyone. In fact, if the little kid's just nibbling on the leaves, you're going to get a good green leafy vegetable into the child's mouth. So there's no harm there. The harm is in our illicit products when people start making stuff and we just don't know what's in it. Cannabis itself is a great plant. So again, patients, outoftime.com. That's where you'll find this information, and I hope to see you all at the conference. Thank you.
Thank you. And that's September 14th through 16th in Charlottesville. And congratulations on your 30th anniversary. We have 18 minutes, but we still have a number of people on, about a dozen people online too.
Hello, Chair. My name is Joe Domino. I'm a representative for the hemp industry. I work as a marketing manager for one of these companies. And I just want to change the perception or maybe the narrative. In the media, we're getting really beat up right now as being the smoke shops, selling to kids, being intoxicating products. And under SB 903, we have stricter standards for our product labeling than a lot of these smoke shops do on their murals. So I just think there's a lot of misinformation, and I want to set that straight and give you a different perspective that we're more functional products, not intoxicating products, and we should allow the consumer to choose what works for them. Now, I'll leave with this. 2 bad reviews from the medical program from Yelp, and 2 reviews I can't share because I lose my banking because we're making claims, but these are customers' claims, not ours. So from the medical program, overpriced, often light in weight, never reply to complaints or emails. Sales and discounts much better from Maryland. Another one, overpriced, low quality smoke. Some of the packages are not sealed, and I'm sure I did not get the full 3.5 grams that I paid for. Twice that happened. So, if this was a real medical product, that would never even happen. 2 reviews from our company. I struggle with sleeping or waking up in the middle of the night. This product works perfectly. I've been able to get a good night's sleep. I'm not waking up randomly in the middle of the night. I'm now a regular customer. Can't live without it, literally. It's the best cream ever. When my hip bursa gets bad, I rub this cream in at least twice a day, and it keeps me from having to take Advil. I also use it as a cure for my dry skin and my suntan cream. It is a wonderful product, and and then Redfern, our company, is a friendly bunch of group of people. So, we really care about our customer service. We care about the plant. We care about our products. We just want to give the right chance, and we want to help the elderly community, not be, slanted in the media as, hurting the youth.
Thank you.
Good afternoon, senators and delegates. Thank you so much for being a part of this commission and for all your hard work. We're going to have many conversations between now and the beginning of session and hopefully the passage of a bill that opens.
I'm sorry, what's your name? And
my name is Thomas Malone.
Hey,
I am a lawyer here in Virginia. I am the policy chair for the Cannabis Small Business Association. I am also the general counsel for Pure Shenandoah, the largest vertically integrated hemp company in the state. Not only do we make THC and CBD products, but we also make industrial hemp for construction materials. We have a contract through the Department of Defense with the United States Air Force for those construction materials. So we do know a lot about hemp. We do know a lot about marijuana as well. We were one of the applicants for the HSA-1 medical license, serving Charlottesville, Harrisonburg, Winchester, out to Fredericksburg. And we were one of the first place tie applicants for that license as well. So that is my resume on the cannabis side. Before then, I worked at the UVA Health in the pharmacy department, directly under Raphael Sains, who is the former chairman of the Virginia Board of Pharmacy. And before then, I worked at the Newport News Commonwealth Attorney's Office. That's my resume on the marijuana side and cannabis side, but I am a Virginian first. I've lived in Yorktown for 4 years, Hampton for 2 years, Norfolk for 2 years, Fairfax for 4 years. I've lived in Charlottesville for 3 years, and I've lived in Harrisonburg for 3 years. So I like to say that I know Virginia and the citizens and their stances on marijuana across the state. And between my resume as a Virginian, as well as my resume as a stakeholder, business owner, and lawyer in the Virginia cannabis industry, I would just like to offer my services, my expertise, my background, and to you as we have many more conversations to come about this process.
Thank you, Thomas.
Thank you.
Good afternoon, Chair and Commissioners. My name is Jabria Kraft. I live in Richmond, Virginia, and I am a cannabis coach and wellness advocate. I work at the intersection of intentional cannabis use, harm reduction, and holistic wellness, particularly with BIPOC and queer and neurodivergent communities. And my platform is rooted in helping people build sustainable and confident and informed relationships with this plant beyond just product hype or fear-based messaging. I'm here today because the manner in which we regulate marijuana is deeply important to me, not just as a professional in this space, but as someone who believes that cannabis is a pathway to healing, autonomy, and community care. I'm motivated to be here because I've seen firsthand how people have been given access to this plant without given the tools to use it in ways that actually support them, specifically their minds, their bodies, and their spiritual health as well. Education is either non-existent or filled with shame and risks instead of benefits and support, and accessibility remains a major barrier, especially for communities who have been criminalized for generations. I would like to see Virginia cannabis as an industry that centers education, intention, and equity, where people are supported in making informed choices, where healing is prioritized over the hype, and where Black and brown and queer folks aren't left behind on a system that was built on their backs. If we don't legalize it correctly, we run the risk of creating the same harmful cycles of over-criminalization, overlooking harm reduction, and deepening stigma, which allows profit to proceed over the rights of people. I appreciate groups like Canna Justice Coalition and others for creating access and opportunities for Virginia to get this right, and I hope that you all support this endeavor, and I look forward to working with you. Thank you.
Thank you very much.
How are we doing today? My name is Chip. I appreciate you letting me speak. Just to give you a little bit of my credentials, I am a small business owner, and I'm also somebody that was arrested at the age of 19 for felony possession of cannabis and did 18 months in prison. So this is something that I have a lot of experience with. However, I also have a lot of experience with regulated markets because I ran a vape shop for 10 years until Senator Ebbins' bill made it ineligible for me to get a license. So something that you guys need to really consider is working with the growers and the black market people and allowing them to come over into the licensure. Because if you don't, it's never going to work. I think you guys can look around and see that there's plenty of other states that have tried similar tactics. And if you don't get the legacy growers involved, it's never going to work out. Okay? First and foremost. The second part of this whole thing is that with the regulations, as it pertains to medical, have almost nothing to do with recreational. So trying to take the medical stuff and the bills and the testing and all of this ridiculous nonsense that was put in place as a choke point to allow only companies with hundreds of millions of dollars into place, there's no reason that you need a pharmacy certified technician on staff at a grow. That's just another price point that you have to pay somebody 75, 80 grand for nothing. They can't even write a prescription. Why are they there? Okay, so this is the kind of stuff I'm talking about. But it's done all over the place. You can look up chickenization. That's a real term, and that's what's happening in every single industry with the consolidation. I believe you guys said in 2018, the licenses for the medical were done. There were 5 of them. 4 of them have only been actually activated, and out of those 4, 3 are owned by the same parent company. Okay, so acting like we have true competition and that this is a fair, regulated market is kind of a joke. As far as the medical numbers go, I've talked to over 4,000 patients in this state, and I don't think any of them go to your dispensaries because it's crap. And they relabel the products that after they're expired. But nobody's testing that because you guys are letting them do whatever they want. And that's now on the CCA. It used to be on the Board of Pharmacy, and they didn't know what they were doing, so it's not their fault. However, what I'm telling you is we're allowing these snowball effects to continue to happen, and it's just making it worse and worse and worse. So you're going to end up with a market that's going to collapse, just like California did. As far as the regulation side goes for the retail market, something that you might want to consider is 2 things. First off, there's a third-party compliance program that's been tested in Colorado, whereby the state agencies aren't the ones that are running all the regulations and all the compliance. There's a third-party company that's the mediator. So it's not an adversarial relationship. Like I'm sure a lot of people are aware, regulators versus the companies that are regulating don't really get along that well. But that was a model that seems to be successful and is also lowering the cost of overall regulation. So it's better for the taxpayers. The second part of this is that if we're going to continue to go down this road we really need to look at the consumption lounges, right? It's been mentioned a couple times before. A lot of these people can't even consume in their own houses if they're in public housing or if they're renting from somebody else. But that's a medical issue. On the medical side, it's not on the recreational side. So there may be some leeway as far as medical patients' rights, but until you put that into actual legislation, there's nothing anybody's gonna be able to do about it. So there's a lot of different things that are not being taken into consideration. And I just wanted to come here to offer some of my experience and expertise to the panel. I've tried to work with the CCA. They don't seem to like me because I know who runs them. So maybe you guys would be a little bit more amicable to working on proper legislation. Because I could tell you right now, the models that are being supplemented, like this Nevada model that you guys have been working on, is not going to work. In California, New York, they're switching over to a farmer's market model because you can't get the licenses out fast enough with all this red tape stuff, right? So that way they can go directly from the grower, set up down at 17th Street with the little fence and the police, and have your farmer's market. That's what people want. They want to be able to taste it, they want to be able to touch it, they want to be able to talk to the people that grow it. Okay, if we're not giving a substantial portion of the profits or the licensure to the people actually doing the work, the growers, the breeders, the people that are putting hands on these plants, instead of the lawyers and doctors and whoever else is here that doesn't know anything about this plant, then it's going to be a total failure, like the medical system has been. Thank you.
Thank you very much. Finally, and there's still 4 people online that are waiting, so
okay.
Don't use the whole 8 minutes.
I will not. Good afternoon, everybody. I'm here to represent the newer, if you will, in Virginia, the hemp beverage folks that are in the room and elsewhere. So I'm the CEO and founder of Mountain High Seltzer. My name is Joseph Kuhn. We were one of the first people in the state, one of the first, to basically have a large-scale retail establishment, which is Total Wine and More, pick up our drinks for mass consumption around Virginia based on all the laws that we currently have. We also recently just became the first to be picked up by one of the largest alcohol and beverage distributors in the state. I'm the first one to ever do that. It's definitely a thing that's coming down the tracks. And when I came here today, I just wanted to let you all know that I do feel that hemp products such as a drink and other low dose products should have a place at the table when we talk about cannabis reform. I think that a lot of folks that go for medical stuff, they're limited a lot of times, in my opinion, to a higher dose medication, if you will, in those establishments. And I do know that there are some lower dose things as well. I just think the problem right now with a lot of this is it seems so separated when it should not be. The hemp and marijuana are very much, they're cousins of each other. They're very similar in what they do. One is marijuana light, if you will, and one is marijuana. And so to me, being in that low dose environment, I jump through hoops all the time that are absolutely ridiculous. Right now in the state, there is a fee from VDAX to $1,000 per location for someone to sell a hemp product. No small business can do that. So even though we have a product that people adore, I have nothing but positive reviews, just like the gentleman that was discussing that earlier today, about products such as these that help with anxiety and depression and other ailments. But the fee is so high that a lot of these places cannot afford it, especially not per location. An example would be I had Markets of Tiger Fuel was an establishment, a retail establishment, gas stations and convenience stores throughout the state. And at one point I had all of them that were selling my beverage with childproof caps and every law and every label thing that I had to do. And overnight I lost 80% of my business with them because they can't all pay, that's like a $16,000 fee. I mean, and I don't have a marijuana license, nor will I probably ever have one. And a fee of that magnitude for something that is marijuana light and is federally legal seems a little excessive to me. Now, I know you guys are the CCA and you're not VDAX, but I do feel that there should be more of a connection between everybody of what we're going to do collectively with all of this stuff. And again, with these beverages, which I know there are other representatives here that are involved in that as well, I think it's something you're going to continue to see grow. And again, we're just here to help, and so that's what I have for today. So thanks.
I appreciate the information about the beverage. Let's talk at the end of the meeting. I want to talk to you since I'm the chair of the ABC subcommittee, and that's going to be an issue I'm sure, coming forward.
Excellent. Thanks. Appreciate it.
Thank you, Joseph. Finally, you're the last one.
Oh, good. Save the best for last.
Yeah.
Okay. I'm happy to be having this conversation with you all. Let me get into the weeds of it, okay? Okay, and thank you, and good afternoon. Okay, and Virginia waited for legalization because we wanted to learn from the mistakes of other states, right? Okay, so, right. Well, what we have learned, we now know that tax on both wholesale and retail doesn't work. Nationwide, doesn't work. Okay. If you want this project to be successful, then don't tax wholesale. It's a better way to get businesses. It's a better way to get businesses started, and customers also like it very much. That means more sales and a successful program. And ultimately, more taxes, because this is what undermines the illicit market, or it will continue. Second, we've learned that if we keep our multi-state operations, the MSOs, second, we've learned that if we keep out the multi-state operators, the MSOs, then the real Virginia farmers will have an opportunity to succeed. Don't push the farmers out. Prevent MSOs from taking all the money out of the Commonwealth. Keep the money here in the Commonwealth. Third, cannabis sales tax should go forward community projects such as funding for schools and after-school programs for the kids. Our tax dollars should not pay for the opioid epidemic, since cannabis has nothing to do with the crime of the pharmaceutical industry. Nothing. It's actually a gateway to get off opioids. Anyway, okay, did they create it? Fourth, equity is under attack. We must establish that this is what people want and need to succeed. Lastly, let's protect workers' rights. And remember that it's our God-given right to grow this plant. Genesis 129-30. Get educated and share it with your constituents. I'm Duke Dunn. I'm co-founder of Virginia Marijuana Justice, VAMJ. I used to be on the High Council of Virginia Normal, but I ran into some conflicts and they didn't like my cape, and they got against our hemp. And
All right, we've got very little time.
I was a
We've got
Navy
four more
veteran,
people.
and then I'm a member of the Veterans for Medical Cannabis Access. I was a member of the Fraternal Order of Police, and I'm a longtime supporter of law enforcement against prohibition, which is now known as Law Enforcement Action Partnership, or LEAP.
I'm gonna.
Signing out.
Yeah, let's end this now. But
Oh,
please,
no, you'll get a laugh on this last part.
hold on.
It'd be
We're gonna.
rough. It'd be almost like
All
you
right,
go high.
we're gonna cut you off now. Do you mind? Because I've got four more people online, and we've only got 2 minutes and 21 seconds.
Okay, got it.
But you're certainly invited back at the next meeting in August to finish up if you'd like. But also,
Just don't blow it. I don't want this whole thing to be going up in smoke.
All right. Everybody,
elevate it.
Let's give him a standing ovation.
Yeah, no.
All right.
Don't encourage that.
All right, we're going to, the clerk will bring Mike Troxel, who's online. If you would tell us which organization you're with and where you live in the Commonwealth. Thank you. Mike?
Apologize. I'm with Virginia Hemp Coalition. I'm on the board of advisors there, and I live in Lynchburg. I think it's definitely high time that we, no pun intended, that we get something done on rec cannabis. Our hemp and cannabis policy in the state has, well, unfortunately, as expected, become a spectacular failure. The General Assembly's own study talks about this pretty clearly. It's pretty clear that the monopoly model doesn't work, and that in and of itself should be enough to abolish the model in an environment that is customer and constituent driven. There are no special exemptions for who can or can't sell alcohol or tobacco, no special regulations for how many licenses there are for it or how far they have to be from a school, etc. Despite the fact that all of them are 21 and over products, there shouldn't be for cannabis either. Adult use products are adult use products, and they should be treated equally across the board. Current age enforcement mechanisms work just fine for alcohol and tobacco and should be carried over on this as well. I'm glad that gentleman mentioned hemp earlier. We should talk about fixing the massive destruction caused the Virginia hemp industry by SB 903 and HB 2294. Some, but not all of that, can be fixed with comprehensive adult use cannabis legislation. Those bills were needlessly destructive to the hemp industry at all levels, and we have the ability to properly remedy that here and should. It's not really a surprise to me that between 2020 and June of this year, there was a decline of approximately 90% in hemp growers, which conveniently seems to also match the 90% of cannabis consumers who get their products from somewhere other than the dispensaries, per the General Assembly's own study. In short, somebody benefited from those bills, and it wasn't the hemp industry and it wasn't consumers, but we need to fix that. And Virginia Hemp Coalition is very happy to once again lead and working hand in hand with legislators to do that. Going back to rec cannabis, there are a multitude of reasons why people don't want to get medical cards, not the least of which are potential privacy issues and or the potential loss of other rights, gun rights for veterans, for example. And it's a bit of a disgraceful slap in the face of every Virginian that there are, last time I checked, 0 Virginia-owned companies selling cannabis in Virginia within the current framework. And I think that rightfully raises more than a few eyebrows.
All right, Mike, your time. Mike, your time is up. Do you want to just quickly wrap it up?
Sure, absolutely. I think we should use a simple set of testing requirements that are not cost prohibitive for small businesses. Keep sales taxes low in order to prevent a black market. Low registration licensing fees for growers. Pardon all nonviolent cannabis possession distribution convictions along with protecting gun ownership rights. Strict 4th, 5th, and 6th Amendment due process protections should be put in place. Look at potentially removing any civil asset forfeiture provisions for hemp and cannabis related items. And whenever possible, default to local choice as opposed to state control. So
thank you very much. Thank you. And I'll say this to everybody that's testified. We really appreciate all the good information, but also stay in touch with us individually and collectively. All right, the next up is, yeah. Yeah, I know, we don't. We have, the time is out, but there's 3 left, and you guys have been so good, and I'm gonna, it's okay if we go another few minutes? Okay. Really quickly, you guys, and I'm sorry that you're gonna have opportunities in the future. We're gonna have another meeting in August, but quickly try to give us a minute or so to introduce yourself, and then also keep in touch, as I've said, so we can follow up with you individually as well. So the next up is it Damien Fagan?
Thank you.
Thank you, Damien.
Thank you very much. Good afternoon, esteemed members of the commission. My name is Damien Fagan. I'm an executive fellow at the Parabola Center for Law and Policy, a nonprofit think tank of legal professionals and drug policy experts that advocate for legalizing cannabis in a way that prioritizes people over corporations. I'm here today also as a proud Virginia native, a graduate of UVA, and as a son who's tired of packing bags of legal products for my mom every time I come home. My commitment to seeing the Commonwealth succeed here is personal, but also informed by my time as a cannabis regulator at the New York State Office of Cannabis Management, where I oversaw the social and economic equity program. I'm here because I believe Virginia is positioned to get this right, and I want to share the most critical lesson I learned. For too long, cannabis prohibition inflicted real harm on communities across the Commonwealth. Legalization gives us a profound opportunity not just to create a new industry, but to build a framework for real economic repair. This begins with the most fundamental decision you will make, which is establishing a true 2-tier market. This means creating a clear legal enforced separation between the businesses that grow and process cannabis and those that sell it. Other 2-tier structures like ours were inspired by the successful implementation of this structure in Washington State and Canada. Minnesota is the nation's newest legal market, also has a 2-tier structure. The model has its critics. When we legalized in New York, corporate cannabis investors called the framework inefficient and uninvestable. They also pointed to the rollout as proof of failure. I'm here to tell you that despite these headwinds of an entrenched illicit market, multiple legal injunctions, the underlying principle of New York's 2-tier system is not just working, it's driving an economic resurgence across the state. Recent market data shows New York is the 5th largest cannabis market in the country, on track to generate over $2 billion in sales this year, hundreds of millions of dollars in tax revenue to be reinvested in communities harmed by prohibition. It's the fastest growing market in the country, poised to pass Massachusetts and Illinois by the end of the year. 400 independently owned small business dispensaries, 400 small independent growers and micro businesses. 90% of all of our licensees are small businesses. 70% of our dispensaries are owned by people with prior cannabis-related convictions. 45% are women-owned, 40% minority-owned. These outcomes are the direct result of intentional equity-driven legislation under the framework of a two-tier market. This is also what healthy competitive market will look like, a market where a license for farmers is actually a genuine opportunity because they have hundreds of locally owned retailers that want to buy their product. Virginia has an incredible advantage of hindsight. You can see how allowing a single company to control everything from seed to sell leads to markets with fewer consumer choices, little to no diversity in ownership or small business access. I urge you to build Virginia's market on this proven two-tier foundation, mandate the separation of producers and retailers. Virginia has the opportunity to create the most equitable and prosperous cannabis market in the American South. A two-tier system is the only way to do this. Before closing, I just want to give a big shout out to Chelsea Higgs-Wise and the entire team at Marijuana Justice and Cannabis Justice Coalition for their time.
All right, we got to cut you off, Damien. Thank you very much. We appreciate you, and I would recommend you might email us your testimony as well, because there's a lot. I encourage everyone to send what you've written down and send it to us if you have it written down. All right, our next up is it Andrea Sparjaswa? Okay.
It's Andrea.
Andrea, sorry.
I really appreciate it. There. No worries. Lots of ways to pronounce it. My name is Andrea Sparjaswa. I hold a master's of public health from Jefferson University, and I work as a researcher and educator at the intersection of public health and cannabis legalization. As an independent consultant, I currently work closely with policymakers, healthcare providers, and nonprofit organizations, including the Virginia-based Cannabis Justice Coalition, to promote policies and best practices that embrace a public health approach to cannabis legalization. And that approach must include impact considerations that go far beyond economic opportunity and market participation within communities that have been historically harmed and continuously underrepresented. As the Commission considers the policy that will guide the shape of the cannabis industry in Virginia, I urge an exploration of the commercial determinants of health, the ways in which the industry actively creates public health and safety consequences or benefits. This should include environmental sustainability, stringent testing standards and product transparency, widespread access to legal market and variable potency products to reduce consumer reliability on unregulated products. And I would argue that this should include hemp market inclusion and mixed ratio or low THC product market availability requirements, as well as consumer empowerment through evidence-based public health messaging. Additionally, it's vital that the policies are designed to ensure specific integration of healthcare access and provider knowledge, allowing for lifelong healthy relationships with the plant and its intoxicating compounds. I recommend dedicated funding for public health research, health communication campaigns, mandated continuing medical education for healthcare providers to improve patient engagement, reduce stigmatized care, and improve outcomes in consumers, particularly through mental health integration. Thank you for opening up the floor and learning from experts in this space as you work toward a system approach in the policies that you're creating. I look forward to helping the Commission create a gold standard for legal cannabis infrastructure, implementation, and valuation that can inform both ongoing state and forthcoming federal efforts. Thank you.
Thank you, Andrea. Do send us that testimony with your contact information. All right, last but not least, we have Micah Sherman.
Hi, thank you so much. And my name is Micah Sherman. Thanks to Cannabis Justice Coalition for inviting me to give remarks here today. I'm a licensed cannabis farmer in Washington State, and I've been involved in policy and advocacy around direct-to-consumer sales and the market crafting choices of regulators in the cannabis economies throughout the country. And I was involved in starting an organization called the National Craft Cannabis Coalition, and we advocate for direct-to-consumer sales as an important part of the market crafting choices that state governments make in setting up their cannabis economies so that farmers and consumers can always have direct access to each other, and that can serve as an important building block for the rest of your economy to function well from. So just here to encourage you guys to take a look at the sort of market crafting options. Damien laid it out real well. With the addition of direct-to-consumer sales to the framework he described, Virginia could hope to have a very nice and fair cannabis economy for your local businesses and consumers. Thanks so much.
All right, well, thank you. I'd like to get your information too, because you've got some good experience up there in the state of Washington. We appreciate you all, everybody that spoke, that testified online and in person. I think the Commonwealth is blessed with quite a lot of experts and a lot of approaches, but we want to do the best we can, and your input is going to make it happen. I'm going to let the commissioners have the final word. Buddy, you have anything you want to add? Delegate Fowler? Anybody else?
Yeah.
Senator Evan.
Can't think of a thing.
Hold on. Okay, thank you, Delegate. Senator Evan.
Yeah, thank you, Mr. Chairman. I just wanted to not lose sight of our overall mission. We heard a lot of good information and a lot of points from some experts, but I think it's important that we make no mistake that we know that marijuana is being sold in this Commonwealth, and thanks to Governor Youngkin's veto pen, the way it's being sold is with illegal untaxed enterprises outside of the medical program. My goal is to move sales away from the illegal market on the street corner to behind an age-verified counter with the tested product, and I think that's a goal that most of the members of this commission share. And how we do it is, a significant charge that we'll have to resolve over the coming meetings. But thank you.
Thank you. Wise words. Final words. That's it. Delegate Price.
No, I just want to reiterate what you were saying about the written testimony. We do look at those, and so it also helps for us to not have to go back and rewatch your testimony. So again, if you've given testimony today, if you will still enter that into the public comment, and if you were not able to, as the chairman said, please go on and send that in so that we can have it as part of the information that we're going over and making decisions.
Thank you for that final admonition. That's good. Well, I look forward to seeing everyone in August, maybe a bigger crowd. August, but it's good to see everybody, and thank you all very much. This meeting is adjourned.